us.
Thank you for being with us today. This is our first webinar, LawTalk. We have LawTalk available through our Leader U every year in June, but this is our first experience with webinar. We plan to offer these every 6 to 8 weeks to help teachers get a handle on what situations they may face and what's their right as a teacher. Today's webinars will be presented by Perry Kraft, who is PET's General Counsel. Perry Kraft is a seasoned litigator with nearly a quarter of a century of courtroom experience. Previously, he served as the Deputy General Attorney for the state of Tennessee. He co-authored a yearly review of Supreme Court decisions for the Tennessee Bar Association. He's very knowledgeable in what he's getting ready to present, and the liability that teachers face with their unruly students, to me, is probably one of the most critical and issues of the day, and certainly one that we can all learn from. Right now, I'm turning it over to Mr. Perry Kraft, and we appreciate him participating with us this evening.
Good evening. If you have questions as this webinar proceeds, feel free to ask them to Bethany.
Via chat.
And she will make sure that I receive them and will try to respond. Today's topic is what's a teacher's potential liability in handling unruly students. Unfortunately, we have unruly students in our classes. Virtually every teacher at some time has more than one unruly student. Some of these students come from very difficult circumstances. Some of them have IEP plans. Some of them have 504 plans. Some of them may have other special considerations, special needs, or special factors. In the middle of trying to teach your classes and your subjects, teachers must deal with these students. I think it's always good to look at the big picture first. Within your class, teachers have wide discretion. Wide discretion, however, is not unlimited, and a teacher's action can be second-guessed by courts, by a school district, by a principal, by the state, and by criminal authorities. A snap decision can lead to consequences that no teacher wishes to go through. So let's begin with the first thing that can happen to a teacher when an incident arises. Let me describe some of the incidents that can arise. A teacher strikes a kid, perhaps unintentionally, perhaps intentionally, perhaps carelessly, perhaps recklessly. A student is humiliated or shamed according to the student and his parents who didn't happen to be in the classroom. A teacher is not considered prepared by a principal or a teaching coach or mentor or another person within the school district. At recess, kids run amok. When they run amok, someone gets hurt, or another student hurts another student. Or it can be in a lab. A teacher is conducting a lab, takes a break to talk to another teacher who comes in the lab, and there's an accident in the lab. Or there's a kid in a classroom. Teacher's attention is diverted for a few moments, and the kid threatens or harms another. There are several consequences that can flow from that. The first are what we call administrative and regulatory. Essentially, these are two types of possible sanctions. The first sanction can come from the school district or the principal informally, and the second one can come from the state. Let me explain. a principal may, depending upon the school system, be able to issue a letter of warning on his or her own. Often, however, the central office becomes involved, and the teacher talks with people, the principal may talk to people in HR, or the school director or superintendent, or other person within the system, depending upon the size of the system and how it's structured. Sometimes these are very formal, sometimes they're informal. Sometimes I'm asked, can a teacher who has tenure be sanctioned or disciplined? The answer is yes, a clear yes, an unequivocal yes. The second question that I'm sometimes asked is whether a tenured teacher can be let go by a school system. The answer is yes, although the school system will have to jump through many hoops. Now, when incidents occur, teachers often are caught unaware. They haven't had a chance to think about it. These incidents occur often spontaneously with little warning, and the teacher has to act on the spot. The teacher doesn't have access to a team of lawyers, doesn't have HR people to go to, and the school system will make a decision. Who is it going to support? The teacher? The kid? The parent? Who? It becomes a very interesting question, and the answer to that question carries grave implications for the teacher. Grave implications. So, let's give an example. Suppose in an ordinary, normal classroom, there is a child. The child, in years past, may have been a special needs kid in a special needs classroom. Now, many of these students are in regular classrooms, and the student may not be able to keep up. The special needs kid may not be able to do the work that other kids have to do or stay as organized. We have seen teachers be disciplined in part because, or attempt to be disciplined by a school system, a kid, a special needs kid, try to stay organized and try to keep up. So things that seem innocent, things that seem common sense, things that seem routine and ordinary can lead to consequences, as in a reprimand, other sanction, which includes a suspension without pay, being placed on administrative leave pending an investigation, or even termination. And here's the rub that most teachers are not aware of. Many systems have a progressive discipline policy. Let me put that in English. You get a warning, a warning letter. If you engage Mr. or Ms. Teacher in this particular activity or a similar activity again, worse things will befall you. A more sophisticated system will put this in a bunch of legalese, but the message is pretty clear. Some teachers will say, well, all this is a wrist slap. Why do I care? The reality, however, is that the more times or time that you discipline in the past, the greater the sanction or the penalty from the school district itself will be. So it's very important, let me repeat, very important to not take those warning letters lightly, put them in the drawer, and think everything is going to be okay and all right. It may be, but it may not be. And the overwhelming number of teachers that have met are fair-minded people. They want to do the right thing. They want their students to learn. They've invested years of their life in learning the craft of teaching. They have to attend continuing education classes and seminars. Many get advanced degrees, having to spend their own time and often their own funds to obtain these advanced degrees. And they tend to think that they're fair with people, people will be fair with them. And while that may be a good rule for living life, getting along with your neighbors and your family and your friends, it may not be the best rule for dealing with a discipline situation by the school system. Let me repeat that. When a letter of warning is given or any other sanction by a principal or the school system, don't take it lightly. Don't put it away. Generally speaking, you may be asked for your side of the story. You'll go into generally a principal's office, perhaps an assistant principal's office, or someone from HR. They will come loaded. They'll have at least one witness, maybe more. They will be prepared, and it's the teacher will be asked, often on the spot or with little warning, what happened. And it's being asked with the benefit of hindsight and some inquiry or investigation on the part of the principal or the school system or the people who work for them. Let me repeat that. Often a teacher is given little warning, sometimes be at the office at 10 or be at the office tomorrow. The principal or someone from central office or both or other people within the school or school system will be ready. They will have talked to the parent or the student or both. They may have talked to some other people, and then you will be asked on the spot to give your side of the story. The last time that I checked, teachers too were human beings who have feelings and emotions. When you're unfairly charged, whether it's any of us, we often tend to say, how could you even say that about me? Aren't you overblowing this? Sometimes that's true, but the acts themselves giving rise to that incident will be analyzed bit by bit, piece by piece, and step by step. So, let me give you an example. This is from one of the many matters that we have been with teachers when these things have happened to them. A kid was unruly in her class, just absolutely disruptive. The kid had sought help from the principal and was given and the assistant principal, and quite candidly was giving patronizing messages. Essentially, you deal with it. Teacher got frustrated, very frustrated, and slammed a book on a desk. And unfortunately, another kid was nearby. And instead of hitting the desk, the book slammed on the kid's finger. It caused the kid to have a cut and a fingernail problem. Nothing all that serious. The school system recommended that this teacher be suspended without pay for a time certain, attend an anger management class, attend disciplining children's courses and studies, and the parents of that kid then went and got this teacher a criminal misdemeanor filed against the teacher. The teacher was able to beat the criminal misdemeanor rap, but one little incident from a kid who had been a pain in the drain all school year. And a teacher's losing pay, a teacher's having to go through the criminal process, and I have yet to meet anyone, teacher or otherwise, who ever enjoyed going through the criminal process, even as a misdemeanor. Let me tell you the other administrative sanction that a teacher can face. To teach in Tennessee and every other state, a teacher has to have a license or certificate issued by the state. And the state will send out a certificate. Some teachers frame them, some teachers don't worry about it. But in order to teach in Tennessee, generally, you have to have a teacher's license or teacher's certificate. What many teachers are unaware of is that the state can revoke, suspend, or affect your license. Let me repeat that. The state, regardless of what the school district does or does not do, can revoke, suspend, or take action that affects your license. If a teacher does not have a license, here's the implication. You can't teach. Doesn't matter how good of a teacher you are. Doesn't matter if you're tenured or not tenured. It doesn't matter if you're the most beloved person in the school district, the community, and the state. Doesn't matter. If you don't have a license to teach, you cannot teach in a public school, with some exceptions. But that's the general rule. So, let me tell you about another little case that we handle. A teacher was accused of coaching some kids on a standardized test. The standards were vague as to what constituted coaching. We were talking with some children, in this case, children who had never taken a standardized test, and the standardized test didn't mean doodly squat. The state issued a proceeding to try to suspend that teacher's license for a period of time. Now here's the rub. Once your license is suspended, it's going to be fairly difficult to get another teaching job. That is a public record. It's not expungible. In other words, you can't remove it. And it will impact your ability to earn a living. So assume that you taught for 10, 20, 30 years or 3 years. You've invested your time and life in the pursuit of education, learning how to teach. The state may take action regardless of what the school board does. Now some teachers have asked me, well, Perry, isn't that double jeopardy? And I tell them, unfortunately, it's not. If you really want to hear all the legal mumbo-jumbo of why it's not, I'll be glad to explain it. But the principal point is that the same incident can lead to administrative and regulatory action by both a school or school district and the state separately. Let me repeat that again. The same incident can lead to the school district reprimanding you, warning you, suspending you, even trying to fire or terminate you, and the state can then take action against your license. There are different procedures if you choose to challenge them, depending upon the sanction or penalty or reprimand or suspension. You have a right to a certain kind of hearing or conference with the director of schools or perhaps an administrative hearing officer that the school district gets to select. That's right, that the school district gets to select. Not you, the school district. The more formal it is, the more serious it is, there will be a court reporter there at this hearing. The school board will put its witnesses on one by one by one. They will have a school board lawyer, and they will detail exactingly what the teacher did incorrectly or wrong. The teacher is there against the school district's lawyers, against the school district personnel, and some people who teachers thought were their friends will testify against them often. The hearing officer is selected by the school board in accordance with state law. Now, there's a right to appeal the more serious it is. That's an appeal to the school board generally, and then to a chancery court. That's a trial court in Tennessee, and then to the Tennessee Court of Appeals. It's extremely time-consuming. It's costly, and it's maddening for a teacher whose principal goal is to teach kids every day. That is just the reality that teachers face every day. So, when a warning letter is given, a reprimand, suspension, or termination, there's an adverse action taken against you as a teacher. You need to take it seriously. You need to think it through very thoughtfully, and you need to talk to someone who understands the implications for you. Let me repeat that. Take it very seriously. And just because the school board says no big deal doesn't mean the state will say no big deal. Let me repeat that because it's a very important point. There's an incident. Say a teacher's accused of coaching inappropriately kids on a standardized test. The school district may offer a wrist slap. Teacher thinks, oh, no big deal. And then later, the state comes back and says, we want to suspend your license for a while, maybe forever. You can imagine when they want to suspend the license forever. That's generally in connection with an allegation of child sexual abuse or other gross misconduct. But you never can be sure what interest the state has and what particular things will trigger that level of scrutiny against a teacher's license. So I'm going to repeat one more time because I think it's very critical that you understand an administrative and regulatory proceeding, whether it's a letter of warning, a reprimand, a suspension without pay, termination, can lead to other consequences down the road. In addition to that, it can also lead to the state itself trying to take away a license. All right. If we can have the next slide, please. Now, in addition to the administrative and regulatory proceedings that can be instituted or started against a teacher, we live in a world where too many people think reflexively, let's file a lawsuit. Now, the courts are there to resolve wrongs. That's our system. It's a good system. It's a fair system. But in the last generation or two, teachers are looked at far differently in general than they were before. And a civil case means they're coming after a teacher or a school district for money because some child or parent or other person is claiming that she, he, or they were hurt. The first area I want to talk about briefly is something called intentional torts. And when I think of tort, I think of something sweet that tastes good, but that's not what it means in this context. A tort is a wrong. Example is a car wreck. It's an accident. Generally, one person is more at fault than the other. And if there's a minor wreck or a fender bender, the person's responsible will have to pay the cost to repair the car. Most people carry insurance, and it's dealt with in that manner. Or if you borrow your neighbor's flat screen TV to watch the Super Bowl, and you break it because you inadvertently tripped taking it back, you've just bought that neighbor a new flat screen TV. Those are the things that are called tort in law. The first breed is called intentional. It means you do it on purpose or you do it with sufficient recklessness that intent will be presumed by the law and the courts. So I'm not going to spend a lot of time on some of these, but I want to talk about a few of them right now. The first is assault and battery. Civil assault and battery, not criminal assault and battery. We'll talk about criminal here in a few minutes. But assault is putting someone in fear of being hit, hurt, or injured in some way. Battery is the actually touching or the hitting. First-year law students spend an inordinate amount of time trying to separate the two. Now, how does this, and you say, well, that's very interesting, Perry. How does that apply to me? Well, suppose a teacher is standing over a kid's desk because the student has misbehaved, and the teacher is angry and raises her or his voice. And suppose, moreover, the teacher just has some scissors in her hands because she was cutting something when she saw this very troubled kid act out yet again for the umpteenth, 100th time in the course of the day, week, and months that school's been going on. This kid then claims that he was threatened, and that pair of scissors were an instrument that could do him, her, or them harm. That kid has at least stated an assault. Also represented a teacher who was trying to defend another student from possible injury. Of course, the student who was making the threats denied it. There were conflicting stories. And sometimes some students will pull out a phone and they'll start making a video of parts of it. They never catch the whole story, though. And what they may find is the teacher's reaction without seeing what led up to it. Well, when there's actual touching, hitting, striking, that constitutes battery. Battery can be as simple as a touch, depending upon the context, but it's real. There are many school systems where corporal punishment is administered. A generation or two ago, paddling was rarely considered sufficient to go to court over. But if a kid has bruises, if a kid can claim some injuries, if it's a kid with an IEP, if it's a kid with 504 plan, all of a sudden that paddling can turn into something else. And there are teachers in the state of Tennessee who have been sued simply because the teacher was told to administer a paddling with a witness present. Let me repeat that. Teachers in Tennessee have been sued because a kid was paddled or spanked and the kid claimed injuries because of it. When the kid claims injuries, his parent or parents or her parent or parent also claim injuries. And so the parents and the child sue the school district, they sue the teacher, and anybody who was around. Let me repeat that. A teacher can be sued for merely paddling a child. I'm going to repeat it again. A teacher can be sued, have to go to court, have to spend time trying to sort out the facts, merely for paddling a child. Related to assault and battery is when a kid's freedom of movement is unduly restricted. So let me put that in plain English. A kid is told to go to timeout, refuses to go to timeout. A teacher or an assistant or someone else with the school, or even other students at the teacher's direction, hold the kid in timeout. The kid is not allowed to move. That can constitute the intentional tort of false imprisonment. False imprisonment is not necessarily throwing somebody behind the bars of a jail. It's restricting freedom of movement. Now, it's not the same thing as telling people to wait in line and wait their turn, but it's taking action that deprives an individual of the freedom of movement. Now, merely because someone sues doesn't mean that he, she, or they will win. But here's what it does mean. It means that a teacher is going to take his, her, or their time, have to defend it. It means that the school system will get involved. And it means that after the fact, people will second guess what you did or what you didn't do. Let me even tell you, what should you have done? So with one teacher, I was in a conference with the school director, and the question is, what did you learn from this incident? We're talking about a kid who had capital T written on his forehead, who no matter what he did he was your royal pain kid. He was trouble in every class. He had got kicked out of one school for a pretty serious reason. And a teacher on the spot is trying to deal with him, protect other students in the class, and has to make a snap decision. So things like assault and battery are alleged. Things like false imprisonment are alleged. I'll tell you another intentional tort that sometimes teachers face. Defamation. It means saying or writing bad things about another person. Bad things that can injure their reputation or injure them in their livelihood. If it's written down, it's called libel. L-I-B-E-L. If it's spoken, it's slander. Very difficult torts to win. Sometimes people say some very unkind things about teachers. Sometimes those unkind things result in a teacher being terminated or affected pretty significantly. If a teacher can say that the president of a parent-teacher organization has said some untrue but career-ruining things about a teacher, such as that teacher's incompetent, no kid learns anything in that class, that teacher strikes kids all the time, those are the kinds of comment that may, let me emphasize, may give rise to the teacher having a cause of action or a lawsuit against the person who uttered it. At the same time, if a teacher speaks out of school and injures another's reputation, the teacher may face a defamation lawsuit by the person who said it. The information has to be false, has to be said in the nature of a fact as opposed to an opinion. But the difference between a fact and opinion can sometimes be very difficult to differentiate. There are other intentional torts. There are scores of them, but these are the ones that teachers typically face. The next thing I'm going to talk about are negligent and negligent torts. Negligence being careless. We miss a stop sign, for instance, when you're driving. You run a stop sign or someone runs a stop sign, you have a fender bender, or it can be far more serious than that. When that happens, there can be injury to your car, or you can be hurt yourself. So, give me an example. A gym teacher is there's kids get to the gym class early. It's the first period of the day. They're running around. They're playing in the janitor's closet, which should have been locked but wasn't. The teacher is then called away to deal with some other errand or concern of the morning. And as she has a huge gym full of kids, here's a loud thump. In the janitor's closet, there are some pretty significant chemicals. These chemicals spill and burn one of the kids. Is the teacher negligent? Was the teacher careless? Should the teacher have done that? That's called negligence. And so let's say the chemical spilled on the kid's clothes. That's personal property, but more significant than loss of a shirt or a pair of blue jeans are the permanent scarring that chemical burns will leave. So the question is, was the teacher negligent? Was the school negligent? Was the janitor negligent for leaving the door unlocked? Or perhaps the lock didn't work anymore and nobody bothered to fix it. These things happen in the real world. What people propose, what actually happens over time, as everyone in this webinar knows, are often different as night and day. And the incidents arise when day has been planned and the horrors of night visit upon a teacher. Now, when you're talking about negligence, there's the first question that the law asks is, what duty did the teacher owe a student, a fellow student, a staff member, possibly even a parent? First question, what duty, obligation, or responsibility? So let me put it in the context of driving a car. Driving a car, there are rules of the road. You have to stop at stop signs. You can only go on green. You have to follow the red light. If you want to change lanes, you're supposed to use your signal blinker, though a lot of people don't. Cars are supposed to have brake lights. They're supposed to have lights at night, and you're supposed to run your lights during the day. One of the rules of the road is that if you're in a lane of traffic, you're supposed to stay centered in that lane. Now, today, all the laws are computerized. We just hit 3 or 4 strokes. We come up with a particular rule of law that applies. In the old days, there was a bound volume about 2 inches thick called Rules of the Road. Be very, very picky. So the first question is, what's the duty? And there's ordinary duties and there's special duties. So if you're driving a hazardous truck, to take the road analogy, you probably have a heightened duty, a higher duty to protect, because what you're carrying can be destructive or deadly to lots of people. So we want to be very careful with hazardous waste. Well, teachers are also typically held to a heightened duty above and beyond a non-teacher, at least in the school setting. After all, the teacher is there and is in charge. You've all heard the phrase in loco parentis, or in place of the parent. It'd be a rough Latin translation. If there's a Latin teacher on here, you can correct me as to the precise definition, but that's the way it's typically stated. So once you have a duty, and in law it's called duty, for negligence to occur, there has to be a breach or a violation of that duty. So let's say that you are in a class and kids are walking around with scissors, and there's orders not being maintained, and then one kid gets cut pretty bad, or a kid has an eye put out. or a scissors jammed in someone's ear. Unfortunately, these things have happened. And guess who is called to answer for it? And guess where the collection plate is passed? On the teacher. The teacher had a duty to maintain order when something as dangerous as scissors, and we got some kids running around. That's a recipe for disaster. The next part of it in law is something called proximate cause, and that's a mouthful, so I'm going to repeat it. Proximate cause. If there are English teachers on here and I say proximate, you probably think you're hearing approximate. No, proximate. What that means is that it's sufficiently tied in time and space and legally between the breach and the injury. You caused it. The concept is akin to or part and parcel of foreseeability. Is it foreseeable what's going to happen? But there's some limits to foreseeability. You can trace back anything we do to the creation of the heavens and the earth. But we don't attribute this webinar to something that happened thousands or millions of years ago. We just don't. So there has to be a time and space connection. And we could talk about any of these concepts till the cows come home. The cows have already come home, and I'm not going to bore you anymore with proximate cause. And then sometimes some bad things can happen, but no one's really hurt or hurt bad. So a teacher strikes the kid who's been a foul-mouthed smart aleck, but the kid doesn't have to go to a doctor. The kid has no injuries. The teacher will not have any civil liability. In other words, the teacher won't have to pay any money to the parent or the kid, but you can have the administrative sanctions, the regulatory sanctions, and even get indicted. Let me repeat. Even when there's no injury, you may not face real civil consequences. In other words, someone won't be asking you to pay a judgment. They won't be passing the offering plate. But still, regulatory, administrative hurdles can arise. That seems strange to some teachers. When I've explained it, they've looked at me and they've said, that's crazy. And I can understand from that perspective why they would think of it that way. But the function of the administrative and regulatory part of law differs from the functions of civil law, which differ from the function of criminal law. Now, we're going to talk about some other liability situations, and then I'm going to proceed on to criminal. Right? The first one, sometimes a teacher may inadvertently hit a kid with your elbow, knock the kid down. Well, kids in the class may say you did it on purpose. There may be a duty to report child abuse. Or a kid may come to your class bruised and battered, and you may have a duty to report child abuse. On those situations, it's best to talk to your principal or assistant principal, and get some guidance. Let them talk to central office. If a kid is suspended, a kid is expelled, there can be due process concerns. Due process is part of our Constitution. It says before the state or an instrument of state can take away a privilege or a right, there has to be due process. Notice and an opportunity to be heard, or notice and a hearing. The notice and the hearing have to be appropriate to the situation. We're not going to treat every slight like it's a capital murder case. Life's too short. The other issues, these are tend to be often called constitutional torts, involve search and seizure. And we really don't have time to get into that tonight. But what if you suspect that your students have some drugs? Or what if your school system has a ban on cell phones or beepers? When can you search? When can you seize? And the seizure relates not just to property, but to a person. The Fourth Amendment to the United States Constitution in Tennessee has a counterpart, protects against unreasonable searches and seizures. Students have fewer rights at school than adults. They still have some rights. Therefore, let's talk about a strip search of a high school or middle school student. Is that permissible? Well, there was a case a few years ago in which the Supreme Court said we hadn't decided this question before, so we're going to say that the school system and the teacher don't face liability, but now be warned, you are. So if you suspect that some kid is hiding something that's contraband, the more serious it is, the best thing to do is to get someone else in your school. Let them know. Let them know. If it becomes a clear and present danger, you may have to act. But it's going to be a fact-specific circumstance. And believe me, you can be second-guessed for what you do. So some student can rat on another student, or if you don't prefer the word rat, tell about a danger, and you're on the spot. What do? Facts and circumstance matter, and they matter greatly. The next part I want to talk about are crimes that teachers can be charged with. Okay? Unfortunately, a teacher can be accused of child abuse, striking a child, even when it's accidental. If you're upset at the time the kid is struck, somebody who's looking at it in hindsight may say it was reckless, grossly negligent, and even rise to the level of intentional or purposeful. There may be duties to report. Remember we talked about battery in the civil setting. Well, there's assault and battery in the criminal setting. And if you put someone in fear for her or his life or limb, or they're going to be struck, that's assault. It may be battery. And a teacher or anyone else can be indicted. That means charged with a crime by a grand jury. Believe it or not, this happens in Tennessee. Let me repeat. Teachers have been charged with criminal assault and or battery in Tennessee for striking a kid. When that happens, the police detective will come out, will talk to the teacher. They may or may not give you Miranda warnings. Everyone knows what Miranda means. But most people don't consider the implications of it. And they think it's going to go away and everything's going to be fine. Well, it may be. Has a pretty good chance of not being. The police or sheriff or other law enforcement has a completely different view of the world than a teacher. All that they're interested in was a crime committed or likely committed, and did the teacher do it? That's it. Sometimes laws are out of sync or in conflict with our values. So, for instance, when I was a student in school many, many years ago, if a teacher paddled or spanked me, my parents automatically deferred to the teacher. Once upon a time, I was judged wrong and was spanked for something I didn't do. My parents said, learn something from it. Don't be in the wrong place at the wrong time. Don't give the appearance false appearances. Be careful in what you do. Very valuable lessons to me. I have no lasting scars or no scars at all from it. That view may not predominate or be in vogue today. Now, let's talk about the one that every teacher fears: sexual. Some kid accuses a teacher of inappropriate touching or of having a sexual relationship with the teacher. Now, in Tennessee and in most states, once accused, it's very difficult to defend. The school systems typically act fast. They will immediately suspend, sometimes without pay, sometimes with pay, pending an investigation. They'll rely upon the police or the sheriff or other law enforcement, and there are, in many of the sheriff police department, there are child sex units or sex crimes units, and sometimes, not all the time, some of these folks have an agenda. They tend to believe these allegations. If someone comes with that agenda, you may not know it. You may or may not be given your Miranda warnings. You may not appreciate them. Most people don't. And then you talk, and that statement will be used against you if they proceed. When that happens, you'll face the possibility, and they don't have to do anything for a long time. They can sit on it. They can come back and ask questions. They can talk to other people. They can find out there have been a similar incident in your file before. It's very important not to put yourself in a position where you can even be charged. Let me repeat that. Do not put yourself in a position where you can be charged. So if you're alone in a classroom with the windows closed and the doors shut, then it becomes your word against the kids. Some kids are extremely persuasive. They may not be telling the truth, but they can be extremely persuasive. So things such as touching, even a hug, an innocent hug, can be misconstrued. So be very careful about touching or hugging. If once a charge of a sex crime is leveled on a background check, even if dismissed, it will be on your record. Be very difficult to ever land another teaching job again. So you have to use some common sense so as not to put yourself in a terrible position. You have to keep a distance between yourself and the students. And it's sometimes very difficult. Some of these students come from all backgrounds, and sometimes the teacher's real love and concern for that kid may be instrumental in keeping that kid on the right course. And yet a kid can be manipulative or be used by someone else to do something that's not in the teacher's interest, and that is an outright lie. And I assure you, once there's an allegation that there's been a child sex incident, the state will find out, and the state will then come after the license. And the other nice little thing about it, or not so nice thing about it, is that it's then reported to every other state and territory in the United States. The U.S. Virgin Islands are a territory. Puerto Rico is a territory. Guam is a territory, and we have others. So it's reported widely, and every state board or Department of Education will report the allegation to any other state. So it's not like you can move to Wyoming and no one's going to know. Okay. I think we have some questions, so I'm going to stop and try to answer some of those.
Okay. I've got one. If a teacher is reprimanded or suspended or terminated, does this put in jeopardy their retirement benefits if they have already qualified for those benefits?
No. The law right now is that there's no forfeiture. That means they can't take it away from you. You have a vested right to those benefits. Now, there's always been talk about changing that, but those were earned. They were earned for doing your job, and they're not going to be taken away.
Okay. I think that one thing we have learned is that obviously we can't control the actions of others, but we can control the actions of ourselves. And one thing is, it's very critical that that we are always in the back of our mind what could or couldn't happen in a certain situation, and just being aware of the things that could happen or could not happen just makes it makes you one up on somebody else who hasn't thought about these situations. Also, I think this webinar has proved how vitally important belonging to a teacher organization is that will defend you and help you with these difficult situations. There's no way that a person that doesn't regularly work with teachers would understand it. So I appreciate Perry Craft, and if you'll see on the screen, you can go to the hot link, or if you have a smartphone, you can scan the QR code and it'll print you a certificate. If either one of these two ways won't work for you, you can email me directly, and I'll be glad to email the certificate directly to you. I appreciate you being in on this webinar with us, and we're planning to have some more in the future. You'll have a 3-question survey when you exit the webinar, and you can tell what you liked and what you'd like to see in the future. Appreciate your time. I'll have a hot link to this in hopefully up tomorrow, so if we can share this information with any of your fellow teachers, we appreciate that. Thank you so much, and have a good evening.
Bethany, I want to add one more thing.
Okay.
If situations arise, you can call the PET office. You can contact people at PET. You can contact us. But I want you to understand the seriousness of some things that you may consider minor and are going to blow over. That can be a very dangerous assumption for a teacher. So I appreciate your listening. If you have other questions, you can email us and we'll try to answer them.
Thank you. I'm going to stop the recording now. Thank you so much for your participation.